Lee Moritz. We will go on the record in the matter 25 CM 113, 25 CM 185, State of Wisconsin versus Lee Moritz. The state appears through Assistant District Attorney Jose Villa in person. We have Mr. Moritz in person without counsel. We're set today in these matters for an initial appearance in the 185 case and a status in the other. Mr. Moritz, did you receive a copy of that new complaint? And that's what it looks like in your hand?
Yes.
Did you read it?
I didn't read the whole thing.
But do you understand that?
Now watch the domino effect. Mr. Moritz violates the order multiple times. Each contact isn't just a little mistake. It's a separate criminal offense. And that's the law working like a laser pointer on accountability. Every single interaction can be charged. Text a message, make a phone call, even ask a third party to contact a petitioner. That's another violation. This is why restraining orders aren't suggestions. They're legally binding mandates. Courts don't just say, please don't contact someone. They create real consequences for noncompliance. And in this case, each violation adds a new layer of potential misdemeanor charges. You can see it like stacking bricks. One contact builds a foundation. The next adds weight. And soon the legal pressure becomes overwhelming. Think about the mindset here. Some people might assume, I'll just send a short message. It won't matter. But that's exactly the trap. The law is strict, and the consequences compound quickly. And when you factor in repeat offenses, the criminal exposure escalates, not just in fines, but in potential jail time. This is also a lesson in strategy, or lack thereof. Defendants need to fully understand that once a TRO is in place, every action is monitored. Ignoring the order or rationalizing contact isn't just risky. It's almost guaranteed to create additional legal headaches. And that's exactly what we see here. The first violation leads directly to the next charge, and that's how Mr. Moritz spirals deeper into trouble. Legal accountability is a chain reaction, and one misstep can pull you straight into court again.
Charge and that maximum penalty?
I really don't.
Okay, well, it's easy. I'll just go over it with you and you'll totally understand. It's alleging that on or around June 13th, 2025, you knowingly, you did so understandingly, that you violated an injunction, which is a restraining order, as people know it in lay terms. An injunction where you're not supposed to have any contact at all in any way, shape, or form at all with an individual in 24 CM 120. So they're alleging on June 13th, 2025, you violated that. You broke the law. You had contact. Don't say a word. You could, upon conviction, you could be fined not more than $10,000 and have incarceration of not more than 9 months in jail. So that's that maximum penalty associated with the charge and what the state would have to prove. Okay, and it's alleging that you did have contact, you knew you had contact, and you knew you weren't supposed to have contact with that domestic abuse injunction, okay? I would not say any facts about the case, because anything that you say here today can be used against you, okay? But if you have a question, an administrative question, I can answer that.
I spoke to Jose and he didn't help me at all. I had a lot.
Not supposed to. He's the state. He's on the opposite side.
Oh, I don't know how this works.
Okay.
I have no idea how this works.
He's the attorney that prosecutes you, that he's wanting to protect the public interest and the allegations in both of these complaints because they're very similar. So he's not the guy who can help you.
Oh,
if you're looking,
I don't understand how any of this works.
Okay. So
I don't have enough money to buy an attorney right now. So
did you talk to, there was a gentleman, and I'm going to
look at this moment carefully. Mr. Moritz admits he doesn't fully understand the charges or the maximum penalties. And honestly, he's not alone. This is incredibly common in courtrooms across the country. The law is complex and self-representation is an enormous challenge. Here's why it's dangerous. When you represent yourself, every misunderstanding can be costly. A misinterpreted term, a misread instruction, even failing to realize the severity of the charge can turn a small legal problem into a major one. Courts don't simplify the law for you. Judges can explain, but they can't advocate for you. That's why the advice here is simple. Never underestimate the value of legal counsel. Notice the human element too. Confusion often leads to stress, frustration, and poor decision-making. When defendants feel overwhelmed, they might ignore instructions, argue unnecessarily, or make missteps that escalate the case. And that's what we see with Mr. Moritz. His lack of understanding isn't just an innocent mistake. It directly affects his ability to comply with legal guidance and avoid further charges. This is a key learning moment for anyone watching. Knowledge is power. Understanding what the law expects, knowing the consequences, and seeking guidance from qualified counsel can literally be the difference between a minor hiccup and a criminal record. And in the next few minutes, we'll see how this confusion leads directly into additional charges and a cycle of escalating legal trouble.
I'm going to try and find somebody outside who can stop. Hey, why don't you please, one of you, run out? Mr. Flisky's right outside, and then we can get Mr. Flisky so he can talk with Mr. Moritz to see if he qualifies. Thank you, Ms. Bauer. You talked to him already?
I talked to a woman the last time I was here.
Okay.
I don't
Apparently we
qualify.
don't need him.
I don't
Apparently
qualify
he doesn't
at all.
qualify. So, but thank you, Ms. Bauer. Okay, so you don't qualify.
But
Okay.
she told me I can only make like $200 a month, and I
No, it's not. It's not that. It's not $200 a month. It's like you probably own property. If you own property,
yeah, I do.
then that's what
I own
cut you
quite
out.
a bit of property.
So what you would probably like to do is retain your own attorney or apply for a court-appointed attorney, but that's still at your cost and you'll still need to have money down. But if that's the route you wish to go, then you need to go outside and get that application when we're done here today. Fill it out today. It can't be any later today because I'm not going to wait until the next hearing to have you go, oh, I didn't do it. So you have to go fill that out today if you want a court-appointed attorney at your cost. It's $100 an hour, but that's far less than the other attorneys. You can pay $300 or $400 an hour for a private attorney. You can go that route too. That's totally up to you. But otherwise, it's a reduced rate at $100 an hour. Having these cases, you would need to pay $350 down.
I don't have any money, Your Honor.
Okay, so at this time, you're representing yourself, and that's fine, and you can do that. Not guilty plea is going to be entered on your behalf on this charge, as well as the last charge. But Mr. Villa, you're not his attorney. You don't represent him. He tried to talk to you about the case. So with regards to this matter and your boots that you fill, what is an offer that can be presented?
Here's a twist that surprises a lot of people. Even if you look broke, the state can deny you a public defender if you own property or other assets. In Wisconsin, the law doesn't just consider your income, it considers the equity in your home, vehicles, and other resources. So, Mr. Moritz may not have much cash on hand, but the court sees property and calculates. You can afford an attorney. This is a common misconception. Many people think, I'm broke, so I get a public defender automatically. Not true. The courts run calculations using strict financial thresholds. For example, up to $10,000 in vehicle equity and $30,000 in a homestead can be excluded, but anything above that counts toward your ability to pay. And once you exceed the threshold, even if you're cash poor, you're ineligible. This is where law and reality collide. People like Mr. Moritz feel trapped. They can't hire a private attorney, and they don't qualify for free counsel. That's where strategic decision-making becomes critical. What assets can you leverage? What payments can you negotiate? And how do you access legal advice without breaking the law? For the audience, take note. Asset-based rules exist in many states, not just Wisconsin. It's a reminder that appearances can be deceiving. Having money on paper or owning property can literally change whether the state will defend you for free. And for defendants, understanding this rule early can prevent weeks or months of court confusion, frustration, and yes, additional criminal exposure.
Your Honor, at this time, I cannot present an offer. We have further cases that are coming down the pipeline, so I'm going to do a global.
Okay, so there's more referrals of the same-ish thing?
Yes, Your Honor.
Okay, so you can understand, Mr. Moritz, from what Mr. Villa is saying is that there are more allegations of you doing the very same thing, and it looks like more charges, more cases are coming down the pike. Okay? So
It's all Greek to me.
all I can do is, all I can say is I can strongly advise you that you need to not have any contact, not only because it's criminally hurtful, but because you have a domestic abuse injunction, zero contact with BR. Zero contact, no texting, no talking, no swearing, no pushing, no third party contact unless it's through an attorney.
Can I talk to you?
I may not be able to give you any answers.
This is my situation.
I don't know if you want to tell me your situation because again,
I want to. I want you to understand.
everything, I can't understand. Everything that you say can be used against this gentleman right over here and he can use it.
Okay, signature bond 101. Mr. Moritz doesn't pay $500 up front. Instead, he signs a written promise to appear in court. Sounds simple, right? But the legal stakes here are huge. Violate any condition, like contacting the petitioner, and that $500 bond can be converted to cash, and he could face a separate charge for bail jumping. Here's the nuance. A signature bond isn't just a formality. It's a contract with the court. You're promising, I understand the conditions, I will follow them, and I accept the consequences if I don't. One small mistake, even unintentional, can turn into another criminal filing. Think about it practically. If Mr. Moritz texts the petitioner, even to clarify a document, he's violating the injunction and potentially the bond at the same time. That means one act could create two separate offenses. Courts enforce these rules rigorously because compliance is the only way to maintain order and safety. And for anyone watching, this is the perfect illustration of how law is strict but clear. It's like walking a tightrope. One misstep, and you're tumbling into more legal trouble. Mr. Moritz is navigating a minefield, and the signature bond is one of the first real hurdles. Remember, read the fine print, follow instructions, and treat every court order like it's legally binding, because it absolutely is.
Even if it hurts you.
But I need to talk to her because she did all my business work, all my taxes, and I need some documents from her to get.
Can't.
But I need that, and she will not give me. That's why I keep.
I would stop. I would stop right now because
I just don't understand what's happening. I don't. I didn't abuse anybody. I've never abused anybody in my life.
But there is a domestic abuse injunction.
It's false allegation.
Well, it's in effect.
Because she came to the court first.
I am telling you right now, I'm not going to go look at the case. I'm not going to look at the facts. I'm not going to do those things.
Well, someone needs to.
There is in effect a domestic abuse injunction that says absolutely zero contact, none whatsoever. No text messages, no calls, no thinking hypothetically or not hypothetically, thinking towards her, no talking to people, not trying to do anything that has any contact with BR at all. Not at all. And if you need contact, you want to know, it says in the injunction, I can tell you right this because it says in the injunction, you can have zero third-party contact unless it's through an attorney. So that's your option.
I don't have any money, so I don't. Yeah, my life's in your hands, Your Honor.
It's not in my hands. It's in your hands because I don't make the choices and I don't have the conduct you do.
And here's the real takeaway. Mr. Moritz had options, and he ignored them repeatedly. Courts offered paths forward. Hire an attorney. Use the assets he owns to secure counsel, or at least communicate exclusively through an attorney. Each of these options could have prevented additional violations. Instead, he chose to argue, resist guidance, and continue contacting the petitioner. This is a textbook example of how refusing accountability escalates legal trouble. Every action or inaction matters. Courts can provide guidance, but they cannot make decisions for defendants. The responsibility to make smart, lawful choices rests entirely on the individual. Think about it as a roadmap. The court said, here's your path to compliance and safety. He ignored the signs. The result? More charges, more court appearances, and mounting legal jeopardy. This is a cautionary tale. Ignoring rules doesn't just delay consequences. It compounds them. For viewers, take a moment to consider the lesson. Understanding the law, seeking qualified counsel, and making measured decisions can literally change the trajectory of a case. Courts provide the framework, but the defendant's choices determine the outcome. And in Mr. Moritz's case, those choices actively created deeper legal trouble. Accountability isn't optional. It's a foundation for moving forward safely and legally.
You're the one who understands what the law is prohibiting and you continue to do it the only way, and through that injunction, it says attorney. So what you're going to need to do is, I'm strongly advising you, at least you can go hire an attorney for this one sole little thing.
I don't have any money, Your Honor. I don't. She took $25,000 from me and split.
I don't know what else to tell you.
I don't have any money, so I don't want to go to jail. I don't know what to do.
I would stop having contact with BR.
But I need some paperwork from her.
And I told you
I
how to
need
do
it.
it. I told you how.
I can't
to do it.
afford an attorney, Your Honor. I'm at your mercy.
There's no mercy here. I cannot be merciful. I have nothing that I can do right here at this time. An injunction says zero contact, any way, shape, or form.
I understand.
Except through an attorney. So you know the
I understand.
fix.
I understand.
And you have the fix. You just have to figure out, problem solve to get to that, to be able to get what you need. I can't give you authority to do that.
I understand.
What I'm going to do, how long do you think it's going to take you to review these new referrals?
Your Honor, less than 30 days.
December 10th at 9:45. December 10th at 9:45. We're going to have the next hearing, and that's a status, and most likely it's going to be further initial appearances.
Here's where the courtroom drama really ramps up. Mr. Moritz is at a crossroads. He needs documents from the petitioner, but legally, he cannot contact her directly. The judge is crystal clear. Any attempt to circumvent the injunction, even for practical reasons, is a criminal violation. This highlights a fundamental principle in law. The court order isn't just a suggestion, it's enforceable. Think about it. He's juggling a real-world problem with strict legal boundaries. Without an attorney, he literally cannot solve the issue himself. This is where legal representation becomes critical, not just for defense, but for navigating day-to-day complications like paperwork, finances, or property. The judge is essentially giving him a map, saying, this is your legal path. Follow it or face more charges. And notice Mr. Moritz's reaction. Frustration, confusion, and a sense of helplessness. That's not uncommon in courtrooms, especially for self-represented defendants. Emotionally, it's intense. He feels trapped between his needs and the law. From an audience perspective, this is a tension that makes cases like these so gripping. You can see the stakes, the human element, and the rigid structure of the legal system collide in real time. It's a cautionary tale. In real life, failing to understand or respect court orders, even with good intentions, can make a person's situation worse. And here, every option the judge lays out, public defender, court-appointed attorney, or private counsel, is a lifeline. The problem isn't lack of law. It's navigating it correctly. For viewers, it's an important reminder. Knowing the law isn't optional if you want to protect yourself, even when life gets messy.
Again, all I can say is from the injunction, Mr. Moritz, and I'm trying to tell you your path and the thing that you can do. You need an attorney to just have that communication. And I know you say you don't have money, but here's the thing. Have you talked to an attorney to see how much money it'll cost just to have that communication?
$1,500 retainer.
Well, how many attorneys did you talk to?
Benson.
Oh, one. There's multiple other attorneys to talk to that don't charge $1,500 retainer just to send a letter to try and get business documents. There's more than one attorney in the world, okay? As you saw, we had at least 4 in here today.
Right.
Not counting the state. Mr. Vila.
Your Honor, it does appear that we also need to set bond for these cases.
All right. The court is going to do $500 signature bond, okay? $500 signature bond. Absolutely no contact with BR or residents.
I have a question.
Yes.
What does a signature bond mean?
A signature bond means you're going to sign the bond. You're going to understand the conditions. You come to court, you follow the law, you don't break any of the conditions. If you do, great, and you don't violate any of those things, then you're fine. You're just signing by your signature. You're saying, I'm agreeing to abide by this. If you violate, not only can the court convert that to cash, well, they have to pay $500 bail, but the state has the ability to charge you for what's called bail jumping. Okay? You're
So-
charged with misdemeanor. So if you violate
I
any
sign
condition,
this bond, and if I don't communicate at all, I don't have to pay money. I don't understand.
correct. You don't violate the bond.
So what, do I sign that today?
Yes, you'll come up here and sign it right here today.
Okay.
I strongly.
Let's take a step back and look at the big picture. Mr. Moritz's story isn't just about breaking rules. It's about choices. Every time he ignored guidance, didn't seek proper legal counsel, or try to handle things himself, he added more risk. Courts can provide guidance, structure, and options, but they can't make decisions for you. That responsibility falls squarely on the defendant. This is a live demonstration of cause and effect in the legal system. Miss a hearing? Temporary restraining orders get issued. Violate an injunction? Additional misdemeanors pile up. Ignore the advice to hire an attorney or use existing resources. You compound your risk. And that's exactly what Mr. Moritz did. From an emotional perspective, it's fascinating too. There's denial, frustration, and a human urge to fix things yourself. But the courtroom is unforgiving, and it's designed to hold individuals accountable. The judge repeatedly lays out solutions, yet every time Mr. Moritz rejects them. For audiences, it's a masterclass in how stubbornness and misunderstanding can escalate legal trouble exponentially. And here's an interactive thought. If you were in his shoes, what would you do differently? Could you navigate this maze without getting trapped by your own decisions? It's an important reflection because, while this is a courtroom story, the lessons apply broadly. Understanding your options, seeking help when necessary, and respecting rules and boundaries can prevent small problems from snowballing into life-altering consequences. Finally, remember, cases like this don't just teach about law. They teach about human behavior, responsibility, and the high cost of ignoring advice. Mr. Moritz's journey is a vivid reminder that accountability isn't optional, and every decision in the courtroom has real, tangible consequences. For anyone watching, it's not just legal drama. It's a roadmap of cause, effect, and the critical importance of making informed choices.
Strongly encourage you to either find an attorney and retain that attorney, or to apply for that court-appointed attorney, okay? And you'll fill out the whole application, but I need proof of your income as well as...
I don't have it because I don't have the documents.
Don't need those documents. I just need you to tell me, I make this much, and this is under perjury. So I make this much a month.
I don't make a steady income. I've been self-employed since 1997.
I understand. You used to cut our grass here. I
Yes,
understand that.
I did, and I lost my job because of this whole situation of false allegations.
Mr. Moritz.
I don't understand any of this. I've never been in trouble with the law.
Here's the thing. You know people who know about the law. I know that. So go talk to people who know about the law and either apply for a court-appointed attorney. That's an option right there. And you don't even have to say, I don't need to know, I make $100 this month, I make $300.
Well, that's the thing. It all depends on the weather. If it rains, I mow. If it snows, I plow. If it doesn't rain or snow, I don't make any money.
You have an idea. You have an idea of how much you make, okay? You have an idea.
I don't make enough to pay my mortgage right now. It's been dry for 6 years.
Then it sounds like you could look at other employment opportunities as well. But here's the thing.
I'm 49 years old.
I'm not going to argue with you.
I don't want to argue,
Then
Judge.
stop.
I just want to go home.
I gave you my options. You have those options. You need to choose one of those options because it sounds like it's going to get a little bit deeper because the state has more referrals. I don't know how many, but it could be 2 or more cases, 2 more referrals.
I text a couple times.
An injunction means no contact. None.
I understand. What if she contacts me, though, and I'm not allowed to contact?
Ignore it.
Can you make sure there's no contact on the bond?
That's what I said.
Oh, okay. I just want to make sure.
If she contacts you, you do not even respond. I can't talk to you because that's violating. Sounds like it's, kind of lopsided. Why can she contact you and you can't contact her?
That's what I don't understand.
That's the law.
See, I don't understand the law. I'm not a judge. I'm not a lawyer.
Block her.
But I need that paperwork.
Here's the thing. Again, the only reason why I know this is because you brought your sister with you at the last hearing, that your sister's a law enforcement officer. You know somebody to talk to who knows the law. She knows the law. She knows the law. She's an officer of over 20 some years, maybe 30. She's an officer.
30 years.
So talk to your sister. And again, I only know that from the last hearing you were here. So you can't be trying to wishy-washy tell me you don't understand the law, you don't know the law.
I don't.
You know an expert, a law enforcement officer. She can tell you all the things.
She doesn't. She's not a lawyer. She's a police officer.
Who knows the law? And if you say, hey, sister, I have a domestic abuse injunction against me with BR, does that mean I can't contact her?
The thing is, it's false allegations. That's not justice.
Okay.
It's all false allegations.
Okay, again,
I just want to go home.
correct. No, you don't want to just go home. You want to continue to argue and to argue and to argue and to argue and to argue. So stop, because I'm not going to do this again. You're getting your one time right now to have your voice be heard, and that's it.
Thank you for letting me be heard.
And I understand you have these issues, but I can't tell you what to do. Only an attorney can tell you what to do and how to go about it. I've given you your options, okay?
Right. Thank you.
So come and get your notice.
Thank you, Your Honor.
We'll see you in December.
Sorry to waste your time.
It's not a waste of time, it's my job.
Whoa, hold up, let's pause here. Notice how the court issued a temporary restraining order without Mr. Moritz even showing up. That's a classic example of how the law can act quickly to protect someone. In Wisconsin, these orders can be granted the same day, which means the stakes are sky high immediately. Imagine waking up to a court order that restricts your contact with someone for 4 years, and you haven't even had your say yet. Think about the psychology here. The petitioner's safety is prioritized, not the defendant's explanation. This can feel unfair if you're on the receiving end, but the law is designed to prevent potential harm before it happens. Judges have to make snap decisions sometimes, relying solely on sworn statements. And that's why temporary orders exist. They're a legal pause button to prevent harm while the court digs into the facts. Now, let's break down the mechanics a bit. A temporary restraining order, often abbreviated as TRO, doesn't require a full hearing. The judge looks at the petition and decides, is there an immediate threat? If yes, the order is issued. This is meant to stop escalation, but it also sets the stage for the next chapter, where the defendant can contest the allegations at the formal hearing. Here's the kicker for defendants. The TRO may feel sudden and even shocking, but legally, it's enforceable immediately. That means any contact after issuance is already a violation, even if you think you're justified. One wrong move here, and you've turned a civil procedure into a potential criminal case. So imagine the tension, walking around under an order you didn't even anticipate. That's real stakes, real consequences, and the start of a legal domino effect that we'll see unfold in just a few minutes. Asterisk.
For the most part, are those facts accurate?
Yes, Your Honor.
Did you get into an argument and into a fight with SB?
I don't believe so.
You don't think you did?
I
Court costs of $443, less than a parking ticket in some cities. But don't be fooled. Quick plea deals like this can mask a deeper story. Legally, a misdemeanor disorderly conduct charge sounds minor, but context is everything. Prior revocations, escalating behavior, repeated patterns. It adds layers to the narrative. Here's the drama. The courtroom presents a cheap resolution. Yet behind the scenes, the stakes are massive. Audience hook. Always ask yourself, what's hiding beneath the surface of simple plea deals? This is a classic case of procedural calm hiding real turbulence. And think about this. Judges and prosecutors make these deals every day. But what happens when they don't have a full story? That's where the tension builds.
I just know that when she dropped me off, she was yelling stuff at me when I drove off.
So what did you do?
I just drove off.
You didn't do anything?
No.
You didn't provoke a disturbance?
No.
Good, we're going to trial. Thanks. We'll set this matter for a trial. Okay. We will go on the record in the matter 24 CM 202, State of Wisconsin versus Andrew Cote. The state appears through Assistant District Attorney Holly Rockow in person. Mr. Cote appears in person in custody with counsel Joel Feliski. We're set today in this matter for a plea and sentencing hearing. The parties have reached an agreement. Mr. Feliski, can you please recite the agreement for the record?
Yes, Your Honor. Mr. Cothey has agreed to plead to one count of misdemeanor disorderly conduct, with the remaining counts in the complaint dismissed and read in, and a joint recommendation by both parties for court costs totaling $443.
And I believe he was in the process of a revocation. Was he revoked or did?
Yes, Your Honor. As of yesterday afternoon, the final decision from the administrator came in, and he has been revoked, and he will be sent to Polk County for sentencing.
Okay. And what charges?
Now here's where unravels the P County charges: possession of amphetamines, cocaine, repeat offenses. In criminal law, repetition builds a narrative the court can't ignore. It signals escalating risk, patterns of defiance, and potential for recidivism. Dramatically, the audience begins to see the trajectory from seemingly minor incidents to serious criminal behavior. And legally, these prior convictions can affect everything: future sentencing, probation conditions, and plea negotiations. Engagement hook. Could you spot the pattern before the court does? Pause and reflect. Criminal behavior isn't usually a one-off. Every repeated action is another piece in a puzzle of prosecution, and the audience must solve.
Was he convicted of in Polk County?
I believe they were substance use related, Your Honor. I was not originally opted into that case. That was my predecessor, Mr. Pollack. Unfortunately, I cannot speak to any detail as to the nature of those charges.
All right, thank you. I can just pull it up. I just am curious. Would be for the 24 cases or for a 21 case, Mr. Cothey?
24?
Oh, 24 case. Okay, so for the 24 cases, possession of amphetamine.
Here comes a pivot. The victim speaks. And suddenly, the courtroom transforms. Her words cut through legal jargon and reveal months of abuse and terror. Legally, victim impact statements can shift the course of sentencing, influence plea deals, and even determine probation outcomes. Emotionally, brace yourself. Broken glasses, smashed mirrors, head bashing, constant fear. She is telling the story the paperwork never captured. Audience hook. Can you imagine living under that constant threat? This is survival under psychological and physical terror, and the courtroom now has to confront the human stakes, not just procedural paperwork. Notice how every detail she provides, every object turned into a weapon, paints a picture far more chilling than the misdemeanor charge suggests.
I mean, as a repeater, possession of cocaine, a misdemeanor. What it looks like. All right. Okay. Basis for the agreement and why it's in the public interest is Raquel?
Your Honor, Mr. Schmidt negotiated this case with Mr. Pollack and Mr. Flasky, but based on my review of the file, I believe that this was based upon the facts and circumstance surrounding the case being relatively minor in terms of the disorderly conduct. There was, of course, the violation of the bail, but that was the Polk County bail. And so it looks like that was all resolved with his latest revocation. So those bail jumps being dismissed and read in is appropriate for that reason. And I don't believe that any additional confinement or supervision is going to be necessary as he is facing that sentence for the revocation.
Okay. All right. So we do have victim SB in the courtroom here today, and Ms. Bauer, SB would like to make a statement. Is that correct?
Yes, Your Honor.
SB may come up here and have a seat at the black desk, and you may provide a statement. If you're going to read something, please read it very slowly so my court reporter can take everything down.
Of course.
I was in a relationship with Andrew Cothy for almost a year. Since we started dating on January 22nd, 2024, I knew there was something wrong with the way he would talk to me or even act. But I was in love. On April 5th, that's when the real anger started. Almost every day from then until the 22nd of October, or the 21st of October, there were fights. He would hit me, but he always thought that he could just make it up. Sorry. On October 21st, we were at a friend's house, and he was on the phone with a friend, and just out of nowhere, he called me the B word, and then threw a car manual at me. Seconds later, he would spit in my face. But once again, made it up, told me he would never do it again. But just a couple hours later, my world flipped around. On October 22nd, about midnight, we left the friend's house and he drove to a parking area in Grantsburg. I ended up falling asleep in the passenger seat, like I always had. He ended up waking me up to ask me where the drugs were. I handed him what he had wanted, and I went back to sleep. He woke me up again and asked me for the other bag. I said I gave him everything I had, and I didn't have anything else. He got angry and started firing the flare gun out the sunroof. The second time he woke me up, he asked me once again, and I told him the same thing I had told him the first time. This time, he got mad at what—
Pause and absorb this. The victim asked for 90 days in jail, no contact therapy, and treatment. And yet, the system is considering letting him walk with just court costs. Dramatically, this is a shock. Real-life trauma meets procedural law. Legally, it highlights the gap between the law on paper and consequences in reality. Audience hook. Does the law always protect victims? Or sometimes, does it prioritize expediency over safety? Think about this. Her daily panic attacks, nightmares, and ongoing therapy are invisible in the paperwork, but they're as real as any legal document in court. This is the moment where the audience feels a tension between justice as process and justice as lived experience.
What I had told him, and he ripped off the rearview mirror and threw it in the back seat. Then he took the passenger visor and ripped it off the car, and then hit me in the cheek with it. The third time he asked, I told him the same thing. This time, he ripped off my glasses, bent them, and broke them. So I thought I was going to try and call for help. He ended up taking my phone and with his two hands, literally ripped it in half. The fourth time he woke me up, I kept repeating what I had told him every time. And this time I looked at him, and I looked in his eyes, and they were black. It was like Andy was gone and someone else took over. The next thing I knew, he started bashing my head against the passenger window. And all I kept thinking was, I have to get away, otherwise he's going to kill me. So I had got him calmed down enough to where he would drive to Dollar General where the van was parked. We were going to move it, but we decided he didn't want to because he was getting tired. He let me drive the car, and I knew that was the only way I was going to get out. I drove the car to the Frederick Trailer Park, where I knew I would be safe. I parked in the front entrance and stopped. He woke up and started yelling, calling me every name in the book, but I was only able to grab my purse, and that was it. I started walking to my friend Jen's house in the park.
Here's the kicker. The judge admits the criminal complaint barely mentions the violence. No glass shattering, no head bashing, no months of terror. That's a legal blind spot. Procedural law relies heavily on documentation, but if the story isn't fully told, justice can stumble. Dramatically, it's almost cinematic. The courtroom suddenly realizes the gravity of what was hidden. Audience hook. What happens when documents underrepresent the crime? How often do victims' realities fail to make it into the formal record? This is a stark reminder that justice isn't just about laws. It's about stories, truth, and evidence being fully recognized.
And I got there and she asked me if she could call. And I said yes. And fell to the ground. The cop from town came and my body started going numb. I ended up throwing up and passing out. Not knowing what was going on, they called the EMTs and I went to the hospital and had a CT scan. Your Honor, this is still painful for me. I have anxiety and panic attacks now, every day. I am actually on nightmare medicine. I don't know the name of it. But I have nightmares every night, every time I sleep, of what he did to me. I am in therapy almost either 1 or 2 days a week, and I will be on therapy for at least 3 years, she said. This was 6 months ago, and yet it still gets to me every day. I don't know how I'm going to move on from this. So I'm asking you for some stipulations. 90 days in jail, no contact with me, my property, or my roommates, no possession of firearms, anger and drug treatment, and probation. I don't think it's fair that I have to live with this every day and he would get away scot-free. He has made it to where I don't feel safe, and I will be putting 2 restraining orders on him for both counties. I can't go outside by myself. I can't go to the store by myself. He's already threatened me enough. Thank you.
Thank you. Just a bit of information. You only need 1 restraining order. It covers you everywhere.
Okay.
So
Thank
you don't
you.
need to go to both counties. Thank you for your statement.
Thank you.
And for the record, and I'm sure that, well, maybe the state had more information, but that's not any of the information that is contained in the criminal complaint. The criminal complaint is very sparse and just indicates that there was an argument and it may have escalated, but what I have access to doesn't discuss the level of what that argument may have been or consisted of. All right, so then the agreement, Ms. Rockow, now again, after hearing the victim, what is the basis for the agreement in the justice or in the public interest?
Well, Your Honor, I think some of that information wasn't information that the state had when this case was charged or when this offer was made. It's not my file, but from my review, I didn't happen upon that, what was described just now. So based on the facts that are contained in the criminal complaint.
And again, and I'll state, you're probably hearing or seeing it for the first time as the court is, because the criminal complaint is one small little paragraph that just describes a fight that occurred and that it may have escalated a little, but none of the detail.
Right. But Your Honor, again, Mr. Kothi has been revoked in Polk County on some more serious charges, and is going to be presumably serving a jail sentence.
Check out the prosecution squirming. They made a plea deal without the full story. Real time, they realize this is a minor. Drama meets law. Plea deals are signatures in ink, difficult to undo, but now the judge knows everything. Audience hook. Could this be the turning point where accountability finally hits? Sit tight. This is a tension that keeps courtroom watchers hooked. Legally, it's fascinating. The law allows for negotiated settlements, but human factors, victim testimony, hidden violence, can pivot the entire course. Emotionally, the audience feels that moment of reckoning. When procedure meets truth, things get messy.
I think at least one of those had some stayed jail time. So I think that he's going to remain in custody for a while. I don't believe that, based upon the facts, that anything more is necessary here. I think that the bail jumps, again, were associated with the Polk County cases. So I don't consider that to be... Of course, he violated his bond. But I think that the focus here in Burnett County should be the disorderly conducts. And I don't think that any jail or probation is appropriate. I do think that costs only is sufficient to protect the community.
All right. And my guess is that the state wasn't aware of, I'm going to guess also maybe the police were not aware of the extent of the argument or what occurred that night, because otherwise I'm questioning why a battery wasn't charged.
Right. I don't have any information about bruising or pain or injury in the file as I review this.
All right. Okay. And he is being revoked, and I'm taking judicial notice of 24 CF 15, 24 CF 224, and 24 CF 310 Polk County matters, in which he has now been revoked on those matters and will go face sentencing in Polk County. I believe in those cases, there is no stay jail time. That was that fictitious thing that some judges do, and they fictitiously say, I'm having that fictitious conditional jail for probation to use if they wish to do.
Understood.
And so, with regards to the charges in Polk, he does have the possession of amphetamine with the repeater, so that means a maximum possible penalty of 1 year he could face, with the increase of no more than 2 years for that underlying misdemeanor in Polk County. But that's for Polk County to deal with and for you to deal with in Polk County. And you were under bond conditions in Polk County when you violated your bond here by engaging in the criminal actions here in Burnett County. And for the record, and this is, I guess, for the victim as well as you, Mr. Cote, for you to be aware of, and perhaps the reason why these were simply charged as disorderly conduct is because of the little bit of information that was provided the day of the incident, at least that I have in front of me. And usually what's in the criminal complaint is what has been provided to the police in the police report. So there's not much. This is the first time that I believe perhaps even the state is hearing the depth of what may have occurred that night. So he's pleading guilty to one count of disorderly conduct, is that correct? And the other count will be dismissed and read in, and he's facing the other charges in the bail jumps in Polk County?
To my understanding, Your Honor, that is correct. It's a plea for one count of disorderly conduct with the remaining counts in the complaint to be dismissed and read in. As has been stated, he has been revoked from probation, and he will be sent to Polk County for sentencing after revocation. I would like to take note that he has been in custody on this revocation hold stemming from this incident since October 31st of 2024. He has accumulated approximately 155 days of jail credit. The conduct has, again, prompted revocation here, in the maximum sentence for a charge of disorderly conduct has been vastly exceeded. He's sat for close to double the amount of time he would for the maximum sentence on this. The public, I believe, has been sufficiently protected. He will continue to reside in custody, awaiting sentencing after revocation. I believe he will be returning to active supervision for his Polk County charges as well. In entering this plea, he is taking accountability for this and does wish to move on. For those reasons, I would ask the court to adopt the joint recommendation. Thank you.
All right, can I have the plea questionnaire waiver of rights form, please?
Yes, Your Honor. May I approach?
You may. So I have in front of me the plea questionnaire waiver of rights form, Mr. Cote. Did your attorney go over this document with you thoroughly?
Yes, Your Honor.
Did he go over it word for word?
Yes, Your Honor.
And do you understand it completely?
Yes, Your Honor.
If you didn't understand it, did you ask him to explain it?
Yes.
And he did so?
Yes, Your Honor.
So you're 37 years old, you have 12 years of schooling, you can read, write, you understand the English language?
Yes, Your Honor.
That's your signature on the second page?
Yes, Your Honor.
You're pleading guilty to one count of disorderly conduct, is that correct?
Yes, Your Honor.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
Did your attorney go over with you the maximum possible penalties you face?
Yes, Your Honor.
No mental illness or disorder, and no alcohol, medications, or drugs?
No, Your Honor.
Because you're charged with crimes, you are entitled to constitutional rights, and each of these rights is listed on this document. Did your attorney thoroughly go over these rights with you?
Yes, Your Honor.
Do you understand them completely?
Yes, Your Honor.
Do you understand?
And now the judge draws a line. No more costs, only deals. May 19th is a drop-dead date. This is justice in action, firm, clear, and uncompromising. Dramatically, it's a mix of relief and tension. The victim sees accountability, the defendant faces consequences, and the audience experiences closure for now. Audience takeaway. The system moves slow, but when it moves decisively. Notice how the judge balances procedure, fairness, and human stakes. This is where law and drama perfectly converge.
And that by pleading guilty, you're waiving and giving up these rights?
Yes, Your Honor.
Do you need me to go over these rights with you in any more detail?
No, Your Honor.
You understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
You understand the state would have to prove on or around October 21st, 2024 in Burnett County, Wisconsin, while in a private place you engaged in indecent, boisterous, abusive, and otherwise disorderly conduct, which under the circumstances did tend to provoke a disturbance. Do you understand what the state would have to prove?
Yes, Your Honor.
Do you understand the maximum possible penalty? The maximum possible penalty of this crime could be a fine of up to $1,000 or up to 90 days of incarceration or both. Do you understand that?
Yes, Your Honor.
Do you also understand I have a recommendation from both of the counsels, both of the attorneys here, a joint recommendation for costs only, that would be court costs and DNA surcharge, etc., costs only for $443. Do you understand that is simply a recommendation to the court?
Yes, Your Honor.
Said differently, that means I'm not bound to follow that, and I could sentence you all the way up to the maximum possible penalty, and I could do that here today if I thought it was necessary and warranted. Do you understand that?
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Did you go over the criminal complaint with your attorney?
Yes, Your Honor.
And again, that's that document that basically says what happened that day and why you were charged with the crime. And albeit it is very short and it doesn't have a lot of facts and it doesn't have as many statements or factual assertions as the victim did state here today, but as it's stated in the probable cause section of that criminal complaint, for the most part, are those facts accurate?
Yes, Your Honor.
Did you get into an argument and into a fight with SB?
I don't believe so.
You don't think you did?
I just know that when she dropped me off, she was yelling stuff at me when I drove off.
So what did you do?
I just drove off.
You didn't do anything?
No.
You didn't provoke a disturbance?
No.
Good, we're going to trial. Thanks. We'll set this matter for a trial. Okay? Sounds like we're going to have a trial on 2 disorderly conducts and 2 bail jumps. That sounds good to me. So maximum possible penalty for 2 disorderly conducts, up to 90 days of incarceration, and for 2 bail jumps, up to 9 months each. Because if you're indicating you didn't do it and you're indicating that you're innocent, by golly, the state has to prove beyond a reasonable doubt. And so I think we're going to set the matter for trial, and I think we need 1 day. Let's set it for trial here today, Miss Rockow. Is this going to be a your case, or is this going to be a Mr. Schmidt case?
This is Mr. Schmidt's case.
Okay, let's get the matter set for trial, and we can do it. I can presume you're going to be in custody for a while, since you are revoked on your Polk County matters. But we don't have a problem getting you back here for a trial. We have a really great lieutenant who runs our jail very well, and we have the ability to do transport. So let's get this matter set, and let's get it set for sometime soon. And we have the victim here, so we can make sure that we have a date that works for the victim as well. How about June 24th? It is on the assistance week, but June 24th sounds like a good day to have a trial. How does that work for you, Mr. Flisky?
I'm available that day, Your Honor.
Excellent. So we'll have a trial on June 24th. That'll be a trial because, again, if you didn't do anything that day, that's what your assertion is.
Whoa. Check that hesitation. Right at the start, the defendant stuttering tells us a lot. In courtroom terms, hesitation can hint at evasion or subconscious acknowledgement of guilt. Emotionally, the tension is thick. You can feel the judge sizing him up like, "Are you for real?" Those tiny pauses, repeated words, and stammering, they're more than nervous tics. They're a psychological window into his mind. The law notices this too. Even small hesitations can influence how a judge perceives credibility. Audience hook. Have you ever noticed how micropauses in speech reveal more than words themselves? Keep your ears peeled. Courtroom gold often hides in subtle tells. And notice how the defendant's body language mirrors his words. It's a full picture of tension waiting to explode.
Here, Mr. Colte, the state has to prove it beyond a reasonable doubt that you engaged in any type of conduct that would be disorderly, and whether or not you were on a bond in Polk County and whether or not you violated that bond, and you did so knowingly. So that's what we're going to do. June 24th, we will have a trial. We only need 1 day. That works for victim, Ms. Bauer?
Yes, sir.
Excellent. Now let's get to my final drop dead date. That means, Mr. Colte, that is the day that I will no longer take any type of agreement, okay? I won't accept any agreement in this case, all right? And so that means the matter will go to trial, and you will be able to have your attorney state your, or actually have it'll be the state trying to prove the case, and your attorney will be able to defend you and your claims at this matter. But on May 29th, that'll be the last day, the drop dead date for any agreement that'll be reached. And quite honestly, to me, the court does not find a disorderly conduct with costs only, especially hearing the statement from the victim, to be in the public interest. So let's do May 29th, Mr. Flisky, May 29th. Well, you said that this is going to be a Schmidt, even though it's on that. So let's do May 19th, drop dead date. May 19th, can you do 10:45?
Yes, Your Honor.
All right, May 19th at 10:45, we're going to have our drop dead date for any agreement that can be reached in this matter. Otherwise, we will go to trial. We don't have to worry about lab. We have confirmation that victim will be able to be present and here for the trial. We're good to go. All right. Thank you. We're adjourned. We'll see you then.
Thanks, Your Honor.